in India, published by Orient Black Swan. Warmest congratulations, Jinee, for a very remarkable book, which we have really enjoyed reading. We are most grateful to our distinguished panelists who have accepted our invitation today with extreme warmth and generosity. Thank you very much. And a very warm welcome to Justice Dr. S. Murlidhar, Ms. Rebecca John, Professor Veena Das, and Professor Neerja Gopal Jayal. The eminences with us today are the tallest figures in their field. Every judgment, brief, essay, or book that they have authored have instructed us in how to think of social suffering and the very issue of human rights. Uh, just, to, uh, just a few words about this path-breaking book before I pass on the virtual mic to Jinee. This remarkable book is one of the first empirical studies of truth technologies in India. It tells a compelling story of the rise of forensic science, especially forensic psychology, to unpack torture at different sites. This work is totally admirable, for social scientists do not really think of studying forensic science as a site. And doing research on torture per se is extremely fraught, as we know. The history of lie detection and forensic psychology in this work is also traced to the work of women forensic psychologists. Jinee most insightfully shows us how forensic psychology and its rise mobilizes gender to quote unquote humanize torture by making a place for itself in the forensic architecture of the state. And this raises troubling questions about for people like us who engage with feminist engagements with criminal law, and raises the question of how human rights or feminism might deploy counter forensics to unsettle the claims made by the forensic architecture of the state. This fascinating book is a must read for every social science and law student. Thank you, Jinee, for writing this brilliant book and for your companionship and solidarity in thinking through law's violence through these years. Warmest congratulations. And with these remarks, I'll now request Juma to make a few remarks.
Thank you, Pratiksha. I too extend a very warm welcome to all of you on behalf of the Center for Human Rights Studies at General Global Law School and the Center for Study of Law and Governance at JNU, and my deep gratitude to our panelists who are here today in spite of time zone challenges and their very busy schedules. Pratiksha has already underlined very thoughtfully why this book is exciting, and our distinguished panelists will interrogate the themes this book offers in greater detail. So I don't want to eat into panel time. But I want to say something that as a law teacher, especially as someone who teaches criminal law, I really want to thank Jinee by letting her know what a terrific intervention this book makes in criminal law pedagogy. As anyone who has taught criminal law in law schools in India will know, law students, generations of law students, they have a fascination for forensic science as a popular vocabulary of truth finding in criminal law. And I think this book demystifies that by being a timely disruptor in that discourse. And I'm actually quite confident that truth machines will find a place in criminal law teaching materials. Now I will hand over the panel proceedings to Professor Neerja Jayal, who really needs no introduction. She is one of the most outstanding political scientists of our time. She has written extensively on democracy and state formations, public institutions, and citizenship. Her book on citizenship and its discontents, published by Harvard University Press in 2013, won the prestigious Anand Kumarasamy Prize of the Association of Asian Studies in 2015. And I would urge everyone to read it. She's at present a professor at the Center for the Study of Law and Governance at JNU. She's also incredibly kind and generous with her time, and an aspirational figure, a role model for many of my generation. Pratiksha and I are incredibly grateful to her for agreeing to chair and moderate this fantastic panel. Over to you now, Nirja.
Thank you so much, Juma. Very generous. And thank you, Pratiksha, as well. My special welcome to our very distinguished panelists. And I know for Professor Das and Professor Lokaneeta, both of whom are joining us from the US, this is a really unearthly hour. So special thanks. It's a privilege to be a part of the discussion on this fascinating book, which locates itself at the intersection of law, science, and policing. The book shows how the truth machines, lie detectors, brain scans, narcoanalysis, that ostensibly replaced physical torture, supposedly reflecting a new kind of human rights sensibility, are actually just another form of what Jinee calls legal violence. I see this as a really important contribution to the nascent field of state violence studies. Speaking as a political scientist, this book illuminates a productive distinction between legal violence and legitimate violence in the exercise of state power, and pushes us to think about the possible implications of this form of coercive confession, as she calls it, for structures of governance and citizenship. But time is short, so let me briefly introduce the panelists in the order in which they will speak, and I apologize in advance for the brevity of the introductions. Professor Jinee Lokaneeta is Chair of Political Science and International Relations at Drew University. She works in the areas of law and violence, political theory, including critical and feminist theory, global human rights, and interdisciplinary legal studies. She is the author of Transnational Torture, Law, Violence, and State Power in the US and India, 2011. And it is, of course, her latest book, The Truth Machines, Policing Violence and Scientific Interrogations in India, that we are discussing today. We will shortly, very shortly, hear more from the author herself about her study of these forensic techniques and what they say about the relationship between state power and legal violence. Justice Dr. S. Murlidhar is a judge of the High Court of Punjab and Haryana since March this year, before which he was a judge of the High Court of Delhi since 2006. As a lawyer, Justice Murlidhar was active at the Supreme Court since 1987, extremely well known for his pro bono work for victims of the Bhopal gas disaster and for those displaced by the dams on the Narmada, also as amicus curiae to the Supreme Court in several PIL cases, including cases involving convicts on death row. He was awarded a PhD by the University of Delhi in 2003 and is the author of the book Law, Poverty, and Legal Aid, Access to Criminal Justice, that was published by LexisNexis Butterworth. At the Center for the Study of Law and Governance, of course, we remember with gratitude the inspiring set of lectures that he delivered in 2013 on socioeconomic rights. Rebecca John has been a senior advocate since 2013 and is one of India's most respected criminal lawyers, with 3 decades of practice at the Supreme Court of India, the High Court of Delhi, and the trial courts of Delhi. She has conducted a wide range of criminal trials and argued appeals dealing with offenses under the Indian Penal Code, the UAPA, the Prevention of Corruption Act, among others. She has represented both accused persons as well as victims, and among her most well-known cases are the Jain Hawala case, the 2G Spectrum case, the Arushi Talwar murder case, which also figures in Jinee's book, the Hashimpura massacre case, the ongoing criminal defamation complaint against Priya Ramani, and the Ankit Saxena murder trial, where she's been appointed special public prosecutor. Rebecca John is a member of the Internal Complaints Committee of the Delhi High Court and a statutory member of the Delhi High Court Legal Services Committee. Professor Veena Das is Krieger Eisenhower Professor of Anthropology at the Johns Hopkins University, which she joined in the year 2000 after having taught at the Delhi School of Economics for over 3 decades. She is a fellow of the American Academy of Arts and Sciences and of the Academy of Scientists from Developing Countries, has received honorary doctorates from the Universities of Chicago and Edinburgh, and awards too numerous to mention, but I'll mention only the most recent one, the Nessim Habib Prize by the University of Geneva. Professor Das has researched a broad range of subjects, including violence, the way the everyday and the event are joined together in the making of the critical, and the relationship between health, disease, and poverty. She's been passionately interested in the question of how ethnography generates concepts and in the creation of a conceptual space in the interstices of anthropology and philosophy. She is the author of too many books to enumerate here. I'll mention only her most recent work, Textures of the Ordinary, Doing Anthropology After Wittgenstein. So apologies for these very brief introductions, but it is a fact that none of our panelists actually needs an introduction, as they say. I will start by inviting Professor Jinee Lokaneeta to talk about the book in approximately 10 minutes. Thank you.
Thank you so much, Professor Jayal, for the introduction, and also to the behind-the-scenes architects of this amazing event, Professor Jhuma Sen and Professor Pratiksha Bakshi, and Pratiksha, whose thoughts and words always lace pretty much everything I do. So thank you for that. Thanks LiveLaw also for hosting, especially Rashid. So each of the panelists today have deeply informed my understanding of law, violence, and citizenship through their inspiring lives and words. And I'm truly grateful for their engagement with the truth machines. So my focus generally has been on the relationship between law, violence, and state power in liberal democracies. In my previous book, Transnational Torture, focusing on India and US, I traced how jurisprudence that is considered the most legitimate state discourse formally condemns torture, yet ends up accommodating excess violence. But how do democracies manage the violence that is accommodated even as torture and excess violence is prohibited? In the truth machines, I shift from jurisprudence to examining state actors who are responsible for interpreting and implementing the laws and safeguards against torture. We know that torture is pervasive in India, in routine theft cases, mostly against those who are marginalized on the basis of caste, gender, sexuality, class, and religion, for instance, in terrorism cases, or in so-called conflict areas, Kashmir or parts of Northeast, and now increasingly against protesters and activists under extraordinary laws like Unlawful Activities Prevention Act that has led to denying of sippers and spectacles in increasingly inhumane prison conditions during the pandemic. The thing that puzzled me is why, in a context where torture exists with such impunity and officials rarely charged or convicted, a discourse on truth machines to replace physical torture appeared. And how does it help understand the relationship between state power and legal violence in liberal democracies? I conducted interviews with police, forensic psychologists, lawyers, and activists in 5 cities, Delhi, Hyderabad, Mumbai, Bangalore, and Gandhinagar, to understand the relationship between law, science, and policing. I focused on the emergence of 3 scientific techniques that I termed truth machines: narcoanalysis, brain scans, and lie detectors. Narcoanalysis is the injecting of sodium pentothal for inducing confessions or information. Brain fingerprinting and brain electrical oscillation signature tests supposedly captures experiential participation in a crime through an electroencephalogram, and lie detectors that measure physiological indicators. The popularity of the 3 tests can be seen most recently in their mention in the horrific Hathras gang rape and murder case of a Dalit woman. My focus is to understand the everyday practices of the state not captured by more monolithic conceptions, whether it is a more Weberian bureaucratic conception of monopoly over legitimate violence constrained by rules, or more Agamben-inspired understanding of a sovereign state's violence over bare life. In the book, I put forward the idea of a contingent state, which refers to the way states constantly oscillate between the desire to be unitary and the inability to do so under certain conditions. The concept of contingent state points to the continually negotiated nature of the relationship between state power and legal violence. For instance, if we just see the emergence of these techniques, it's both a story of a disaggregated arbitrariness on one hand and state intentionality on the other. There were some ambitious forensic psychologists in forensic science labs in Gandhinagar and Bangalore wanting to gain visibility legally and in public that led to the popularization of these techniques. But they also fitted the post colonial states' desire to appear as using scientific and modern techniques, in part due to the critique of the human rights movement that was consolidating in the 1990s, and also when institutions like National Human Rights Commission and the Supreme Court jurisprudence on torture, such as DK Basu, emerged. The aspirations of individual forensic psychologists seem to merge with the need of the post colonial state to use science and expertise to find technical solutions for police torture. The ills of the Indian criminal justice system were to be addressed with no regard for reliability or validity of these techniques or their coercive aspects. Of course, the truth machines don't actually replace torture because they got used in very few cases and they often got used alongside physical torture for terrorism cases in order to get particular answers. As a detainee in the Mumbai blast case of 2006 said about a forensic psychologist, and I quote, "She slapped me strongly and started pinching my left ear with pliers, because of which I suffered much. She asked me many such illogical questions and used to ask me to repeat the answers if I did not give the expected answers. Both tortured me badly during the narco test." End quote. The contingent state then helps us think about the role of other actors involved in policing. The forensic psychologists who claim that they are different from the police and provide therapy as an extension of the machine, almost as a cyborg. As one psychologist said, and I quote, "While torture is an external stimuli, these techniques are internal ones and invite an internal journey. They force you to review your past in a different way, not confess, but ask them to think about themselves and come back. It's a moment of catharsis in the legal system. Unlike the police custody, where there is a fear of encounter or custodial death or torture, here there is empathy." End quote. In the Mumbai blast case of 2006, Abdul Wahid Sheikh, the only one acquitted in the case, also initially believed that the truth machines conducted by the doctors would reveal the truth about his innocence until he realized that it wasn't to be. The psychologists even claim that the techniques won't work if the persons are physically harmed, gesturing to a shift, but then, of course, end up creating the same conditions that prop up physical torture by utilizing these coercive machines to get confessions involuntarily, and therefore need to be squarely rejected. But the management of this violence and the actors beyond the police are important to recognize in their disaggregated and multifaceted form. Finally, the contingent state helps capture the experience of those impacted by the violence that interestingly has points of intersection with the police accounts. In the two terrorism related cases that I discussed, many state or semi state actors, such as the medical professionals and magistrates, help hide torture of the Muslim men, creating a kind of a scaffold of the rule of law. The idea of the scaffold is that the very procedures that are meant to be safeguards against torture, to be brought in front of a magistrate and subject to medical examination, often become just bureaucratic check marks that end up hiding the violence. Something that happened even in the Jairaj and Benix case the custodial death cases in Tamil Nadu in June. Yet Sheikh, in his powerful book Beguna Kaidi, also reveals what the police are constrained by: a dead body in custody. I quote, लेकिन याद रखिए, पुलिस आपको टॉर्चर से मार नहीं डालेगी, वो तो केवल इतना मारेगी कि आप डर कर उसका काम कर दें, वो इस तरह नहीं मारेगी जिससे गहरे जख्म हो. But you should remember that the police will not kill you with the torture. They will only beat you to the extent that you agree to do their work. The police won't beat you in such a way that there are physical wounds. End quote. This sentiment is echoed by a police officer in a training academy who connected the human rights movement, the NHRC reports, and the DK Basu case. These, he believed, collectively made the police much more nervous about deaths in custody. I quote, the suspect's safety is in your custody. You don't want him to die, so you take care of him, your brother. You are scared of death, end quote. Often in understanding the police as either a colonial continuity or inspired by the more Marxist conception as repressive institutions of the state, these insights are less revealed. And in this limited sense, I term it the pastoral role of the police mediating the coercive. The emergence of these truth machines thus help one understand the vacillations of the contingent state and whether there are shifts and cracks possible in both the narratives and practices of the state that have life and death consequences for those who experience state violence. Thank you so much.
Thank you so much, Jinee. That was splendid. Thank you. And may I now invite Justice Dr. S. Murlidhar. We look forward to hearing your comments over the next 15 minutes.
Thank you, Professor Jayal. It's a pleasure being on a panel which is chaired by you. Good morning, Professor Vinay Das, Jinee, and good evening, Rebecca, Pratiksha, Juma. It's a pleasure to be on this panel, and I must confess to being completely fascinated by the book Truth Machines by Jinee. It's a very, very important contribution, Jinee, that you've made to understanding the interrelationship between state power and legal violence, and how law plays a very important instrumentalist role in achieving the ends of scaffolding of the rule of law. I'll come back to it later. I found that the most fascinating chapter in your book. I thought of describing something more about the book, but you've yourself given a wonderful description of your central theme, which is that the avowed reason for use of truth machines, that it will somehow replace physical torture, is a myth. You've demonstrated it brilliantly by the use of materials and case materials and personal narratives to tell us that truth machines are just one more arsenal in the huge toolkit that they have to sustain the use of coercion and physical torture as a main device for investigation. I was very intrigued by your description of what you call a contingent state. You see it as being disaggregated, decentered, multi-layered, pluricentered, and fluid. I must tell you, Jinee, you've given a book where it's not only the jargon of political science, but the jargon of law and the jargon of sociology. All of these sit comfortably. And it's a great achievement. I don't mean it as a criticism, but it is an educative experience for people like me who are used to only reading the legal jargon most of the time. So you also talk about the everyday acts of state agents which go to form the state and the law, which is so fascinating as a concept for somebody like me, who is always working from within the law and within the institutions and interacting with them. I must first focus on two chapters, which is chapters 5 and 6 of your book, which is of immediate interest to me. Chapter 5 is on courts. You tell us how the high courts easily bought into this explanation that the police gave, that the scientific investigation methods would somehow be a replacement for physical torture. And many high courts in the initial phase actually justified coercive ways of, submitting the arrested people to these truth machine techniques, saying that, they are a good replacement for physical torture. And you show how that was not true at all. Your critique of the important decision of the Supreme Court, which focused on these three truth machines, namely the lie detector, narco analysis, and brain mapping, and asked the very fundamental question, by using these techniques, are we not violating the fundamental right against self-incrimination, which is enshrined in Article 20, sub-Article 3 of the Constitution? And your critique of Selvi is absolutely bang on. You say, while they did say that this is illegal, that is the coercive extraction of truths, as they were, by using these techniques would be unconstitutional, they somehow permitted voluntary submission, despite there being evidence in the Supreme Court that these techniques were themselves flawed. I just want to read, for the benefit of the larger audience, this passage from your book, I think, which captures it very beautifully. You say some of the contradictions in the Supreme Court's decision on the investigative techniques can only be explained if one considers this unrelenting faith in science. For example, the court says, it is also quite evident that all three impugned techniques can be described as methods of interrogation, which impair the test subject's capacity of decision or judgment. Yet, the justices claim, going by the language of these principles, we hold that the compulsory administration of the impugned techniques constitutes cruel, inhuman, or degrading treatment in the context of Article 21. As a corollary, if it was not compulsory, it would be somehow permissible. You also point out how one of the justifications given to you by the police, you talk to many of them, and I'm also fascinated by how you quote what they say, all those grammatically incorrect sentences, sentences in Indish, but it makes a fascinating read. It's as if that person is sitting before you and talking. And I think as a researcher, you made such a convincing case by not interfering with their words and giving it to us as they said it to you. Those police officers told you that, there are so many constraints, internal constraints that we have. One is this time limit for custody. We can't keep a person in custody beyond 14 days in police custody. And then there is reliability of the evidence. People think this is going to be entirely unreliable, so we have to do something about it. Therefore, but I think one of the main reasons they gave you for continuing physical torture was recovery. For the larger audience, which not may be conversant with this, there is a section 27 of the Evidence Act, which states that the rule of exclusion, that is, that statements made to the police while in custody would not be admissible in evidence. That rule of exclusion has an exception. That exception is contained in 27, which is so much of that statement will lead to discovery of a fact. That will be admissible. So you question how the Supreme Court has added a caveat to its holding when it says that information or material that is subsequently discovered with the help of voluntarily administered test results would still be admitted. So you question this, very conclusion of the court, and you say, thus in upholding the voluntary use of these techniques, the Supreme Court ends up reflecting a general faith and openness in reliability of these scientific techniques, despite noting its contradictory effects. So I think this is a very, very important contribution you've made to understanding what the Selvi decision actually does and how it actually does not probe deeper into those very conditions which make physical torture actually possible. And here I must share with you, I have myself as a lawyer, and here I speak as a lawyer, less as a judge, although I do encounter cases as a judge of cases of physical torture, coerced confessions, and involuntary statements which are sought to be put forth as evidence. There is this question that always arises in one's mind as a judge. What makes this possible? You see, at the end of this whole book, you might use any number of scientific techniques, but still you can never be sure that whatever is extracted through these techniques is actually voluntary. You may have statements signed by people saying it is voluntary, it's not under coercion. You may even have testimonials to say this is not under coercion. But, as we saw in the Parliament attack case, when you're presented before a television camera with the policeman actually standing out of sight of the camera, but still there in the room, your statement is no longer voluntary. So this is always, is a central question that confronts the courts and the judges. What is truly voluntary? And whether this distinction that the judgment of 1961 of 11 judges of the Supreme Court in this famous case, which goes by the name of Kati Kalu Ugad, where they made a distinction between what they call as physical evidence, which is part of your body, like your fingerprints, like your blood, which would include, I suppose, the DNA. All this can be extracted from you without your consent. These are also truths which your body hides, right? They made this distinction between physical evidence and what they term as testimony. Testimony, they said, something which forces you to speak. When it came to the Selvi decision, fortunately, the Supreme Court didn't buy into this argument that brain mapping and lie detector are not testimonies, and therefore they should be treated on par with the other forms of physical evidence like fingerprints, handwriting, blood, and all of that, which is there in section 53 of the Code of Criminal Procedure. They didn't buy into it, and they said, even through brain mapping, even through lie detector, you're deriving certain impulses from the body, certain signals from the body, and which the person has no control of, and that would amount to a testimony. So that was an important distinction to make, and it's a departure from the earlier trend of decisions. But the problem still remains. I would want to pose this as a question to you, Jinee, and maybe Rebecca, definitely. Can we still make this distinction between what we call as privacy of the physical and privacy of the mental? If Rebecca will recall, they tried to advance an argument in the Parliament attack case that under section 27, you can even discover a mental fact. But the court was hazy on that, did not agree with that contention. But really, can we make this distinction, like under section 53, for people who may not be aware, any person arrested can be compelled, and this is there in the statute, can be compelled even by the use of the force that is required to part with his blood samples, a whole range. It says the medical examination would include examination of blood, blood stains, semen, swabs in the case of sexual offenses, sputum and sweat, hair samples, and fingernail clippings, with the use of modern and scientific techniques, including DNA profiling, and such other tests with which the registered medical practitioner thinks necessary. And another provision in the CRPC, which is relevant in this context, is section 293, which says any report of a government scientific officer in all these labs, the forensic science labs, it will be admissible in evidence. Of course, it should be rebutted, but then the burden shifts to the accused. A third aspect of this whole debate on, can we make this distinction between physical evidence and testimonies when it comes to Article 20, Sub-Article 3, is the fact that in India and in England, and Rebecca will bear me out on this and educate us on how the law has shifted, if at all, we still consider admissible evidence that has been illegally gathered, as long as it is relevant. Whereas in the US, they have a clear rule that an illegally gathered evidence is simply inadmissible. So, Jinee, just to add to your understanding of what could prompt the police officers to still persist with torture, I think they all also realize that although the evidence may be gathered illegally, as long as it is relevant, it could still be admissible. You could still convince some court about it, and what this illegally gathered evidence leads to, that would definitely be admissible. So I think your book actually throws up this fascinating question of, what should we consider as really voluntary, involuntary, and can we just have a blind faith on scientific investigation? My next question, and again prompted by your book, Jinee, is the solution to the fallibility of science more science? Just by having more and more, definitive or reliable scientific techniques, can we overcome your basic criticism that there is something flawed in this art of governing through scientific techniques, and softening the blow of the harsh face of a liberal democracy, which is through coercive techniques of policing? So that is the next question that we need to examine. A third issue, and I'll come to that in a minute, because that flows from your chapter 6, which is on the scaffolding of the rule of law. And this again, absolutely fascinating. And you talk of how there are several actors, both state and semi-state, which contribute by their everyday acts to the scaffolding of the rule of law. And how the courts are very satisfied, if all the procedures, the reports are all written up to satisfy this requirement, and will not go further to examine whether in fact the evidence so gathered is reliable and admissible. And among the actors you name which contribute to the scaffolding are magistrates. Of course, you name prison officials, you name doctors, of course, the forensic scientists, and the police. But my immediate focus was on magistrates. You're so right in pointing out that magistrates don't perform a very, very important task which they're expected to when an accused is produced before them. Ask simple questions. Now, have you been subjected to any coercion, torture? Of course, the man will not be able to say with the investigating officer standing right next to him, just behind him. But very often, as it happens, magistrates are so burdened with work that they may not even have the time to engage with the prisoner in the manner they're expected to. I've said this elsewhere. A magistrate performs a very, very important constitutional function. In fact, he is at the gate of the criminal justice system. He, in fact, has to ensure, or he or she has to ensure that there is a meaning given to the constitutional guarantee of life and liberty. If he or she does not they fail to ask that fundamental questions which may give insights into how the prisoner is treated in custody, a very fundamental duty would be not performed by the magistrate. Very often in the high courts, when we take up anticipatory bail applications, and Rebecca is better equipped to speak about this, the prosecution will be saying that he does not cooperate in the investigation. And the accused will say, no, we will cooperate in the investigation because we do not want police custody. And as you rightly point out in the book, police custody becomes a euphemism for coercive methods of interrogation. So everybody at the anticipatory bail stage is trying to avoid this coercive. So all magistrates are aware of how the system works. What is the implication of the police asking for custody? What is the implication of these extraordinary laws like UAPA and Mukoka and others, which extend the period of police custody from the normal period of 14 days? They're all aware of it. And therefore, magistrates perform that extremely important function. And the question I wish to pose is this. When we talk of independence of the judiciary, I think, excessively focus on the constitutional courts, the High Court and the Supreme Court. But we really don't discuss the independent functioning of the subordinate judiciary. They are the ones meeting the people entering the criminal justice system first. They are the first point of contact. I mean, after the police, the next point of contact is the magistrate. Now, if the magistrate does not realize the function being performed by her or him as a constitutional function, then you're bound to have a miscarriage of justice. Jinee, I'm amazed how you used the case materials, and particularly in the Mumbai Blast case, and Rebecca would have noticed, it's amazing that in the Mumbai Blast case, so many accused got into the witness box. So if you find the footnotes, you'll find a large reference to defense witnesses, which normally doesn't happen, Jinee. Any of the terror-related cases or 90% of the criminal cases, accused don't get into the witness box. It's a very risky proposition, and no seasoned defense lawyer, including Rebecca, will easily advise an accused saying get into the witness box. But because they got into the witness box, you could have personal narratives which you've put in quotes of what happened to them when they were taken for a narco or some other lie detector kind of a situation. Since you've been able to use as a researcher the case material so well, I was just posing this question to the larger audience and particularly to Rebecca. Should we not be asking for the archiving of police records? What we don't have access to, even the defense doesn't have access to, is all the material gathered during investigation. Unlike the United States, where private lawyers, defense lawyers can actually themselves do investigations, here you're entirely dependent on the investigation with the police. And for those who may not be aware of this, the police, when it presents the charge sheet, will present only so much of the material gathered by it in investigation, which proves the case of the prosecution. If it keeps back some material, and the defense is unaware of it, the court will be equally unaware of it and you may not have access to it. So the question is, and this was prompted by the incident of the Guildford 4. Again, for the larger audience, there were people accused in the Guildford bombing in 1974 in England. And it turned out in that case, the main plea of the accused that they were not present in Bristol, where in Guildford, where the bombing took place, could not be proved by them because one of the statements of the witnesses who could have proved their alibi, that was kept away from the defense. It is only 10 years later, when a visiting lawyer in the jail got access to the police records, did she come across this file which said not to be shown to the defense. And those cases, the cases of Guildford 4, Birmingham 6, led to the formation in England of the Criminal Review Commission. And that is like the court of last resort that we saw in the, operationalized by Ernst Stanley Gardner, Perry Mason, where they get access to the entire case material and they're able to see where the miscarriage of justice has happened. So maybe in India, we should now push. It can only happen from a collective reading of all material, including this wonderful work of yours, Jinee, that can point to the fallibility of scientific evidence and the need to resist the continued use of physical torture in policing, and that being the main tool of investigation. I have many more questions. I'll keep it for later. I'm sure I've exceeded my time. Thank you, Professor Jayal. Thank you, Jinee. And thank you all.
Thank you so much. It was fascinating listening to the points you made about voluntariness and consent, which of course Jinee deals with in the book, but also the excellent point about the privacy of the physical and the mental and the boundaries there. And of course, the role of the magistrate and the final suggestion on the archives. Wonderful comments. And thank you. We shall come back to many of these, I'm sure, in Jinee's responses and beyond. May I now invite Rebecca John, please, to make her comments on the book?
Thank you very much, Professor Jayal. Thank you so much, Jinee, for this book. And I hope we can have a larger discussion on some of the points that Justice Murlidhar just threw up. I made note of some of them, and so I'm sure that will be part of the discussion later on. Jinee, your book is an important contribution to the field of academia that attempts to understand state violence and the criminal justice system. And I'm delighted to be here today and will make my comments based on my experience as a practitioner in the field of criminal law for the last 3 decades. One of the central premises in this book is mentioned in the introduction, where it is stated, and I quote, "The rule of law, I theorize, represents a scaffold that relies on procedures to mask violence. The scaffold in turn depends much on doctors and magistrates as on the police to perform the work of interrogation. Only when the scaffolding is identified can the underlying violence be revealed and contained and substantive resistance mounted," unquote. The identification of the nature of the scaffold, as theorized by Jinee, along with actors that help create and recreate that scaffold, is an important task. This important work provides us with a focus on the role of doctors, magistrates, and forensic psychologists in enabling violence. The book also provides us with an invaluable history of the emergence of the discredited technologies, lie detection, narco-analysis, and brain mapping techniques termed as truth machines. The fallibility of these techniques is starkly demonstrated in interviews in the chapter related to the Mecca Masjid case, which show how truth machines themselves can be manipulated and how they fail to diminish or end the use of torture. In interviews with police personnel, an explanation for the rationale for the adoption of truth machines is postulated as a method to replace torture and third-degree methods of interrogation and prevent custodial deaths. Different reasons are given through the book, which attempt to explain the adoption of truth machines, including a quest for truth, market forces, and a manifestation of a post-colonial desire for modernization. In my experience, in addition to these possible explanations, courts and those who operate within this space also view, as Justice Murlidhar said, science as objective and infallible. Science and scientific techniques appear as obscure and mysterious, an almost magical source of truth in public consciousness. The constant, unmitigated, and continued use of torture has not lessened despite the introduction of truth machines, as is recognized in the book. Jinee argues that the attempt to replace physical torture with truth machines in India fails because it relies on a confessional paradigm that is contiguous with torture and shows that, in fact, torture and narco-analysis techniques are simultaneous. Truth machines were unable to replace techniques of torture which persisted despite their introduction. However, the failure to end torture is more obviously linked to the impunity with which state and semi-state actors continue to operate in this space, which belies the reasoning provided by police personnel in their interviews. It is vital to interrogate this impunity and the practice that sustains it. Today, the search for truth through scientific or technological means continues. But there appears to be a shift from the use of truth machines to the embracing of new technologies that bypass the constitutional prohibition against self-incrimination, technologies that depend on the body, including DNA analysis, on the seizure of electronic devices. In our work, we have noticed that emerging new confessional paradigm in the form of contents of personal electronic devices and the worlds contained within them that is at present unregulated and avoids the bar on admissibility of confessional statements made to the police entirely. Jinee Lokaneeta recognizes that custodial torture remains rampant and even routine in India. It has been 24 years since the landmark judgment of the Supreme Court in T.K. Basu versus State of West Bengal, which strictly censured custodial torture and laid down binding guidelines to end or minimize its occurrence. However, just this year, following the gruesome custodial torture and deaths of Benix and Jairaj during the COVID pandemic lockdown, which so deeply shocked the entire country, the amicus curiae in the case Abhishek Manu Singhvi has filed an application in the Supreme Court seeking revival of the proceedings in the landmark TK Basu case. The application states, and I quote, "As per 2017-2018 annual report published by the NHRC, it received 1,636 intimations concerning death in judicial custody and 148 intimations of death in police custody during the year 2017-2018. For the year 2016-2017, the Commission had recommended prosecution in 4 cases and departmental inquiries in 16 cases. That is 1.2% of the approximate 1,750 intimations it had received in the period." Unquote. Custodial torture at the local level of the police station continues as normal and routine part of everyday policing. It is stated in the book that torture has become more visible by studying its replacements. Today, custodial torture is more and more visible with the rise of a global movement towards greater police accountability, increasing media coverage, and the use of social media. Recently, an activist who was arrested in the Delhi riots case was produced before the magistrate for remand in a wheelchair with fractures on his legs and arms. An inquiry was ordered by the magistrate regarding the injuries sustained by the accused in police custody. However, it was never carried out. While Professor Lokaneeta's work provides an important insight into how the police themselves attempt to justify the adoption of truth machines, the underlying logic of the prevalence of torture is the simple fact of impunity for perpetrators. The rationale offered by the interviewees and the thread running through the book does not explain the brutality of the police in dealing with those accused of crimes big and small. The point I'm making is this: investigating agencies don't have to resort to subterfuge, camouflage, or techniques to replace torture. The persistence of torture is obvious and conspicuous, and it takes many forms. On 28 November 2019, the burnt body of a veterinary doctor was recovered from a highway in Hyderabad. On 29 November 2019, the police arrested 4 lorry drivers and cleaners between the ages of 20 to 24 for the offenses of gang rape and murder. On 4th December, the police sought and was granted 7 days police custody. Public opinion had already pronounced the accused guilty. On the morning of 6 December 2019, the country woke up to the news that all 4 accused had been killed in an encounter under a bridge on the Hyderabad-Bangalore highway while they were in police custody, triggering a chorus of praise for the Hyderabad police, as many saw it as speedy justice. Not only was the police theory of acting in self-defense bizarre and implausible, but the summary execution of 4 suspects was celebrated by many as a victory of good over evil. In chapter 2 of the book titled Police as a Site of Power, Jinee recounts an incident described by her by a forensic psychologist. She writes, and I quote, "One forensic psychologist described a case in a rural area in which the police had been unable to solve a crime. Angry crowds surrounded the policeman, and in order to extricate him, the police claimed to be subjecting the suspect to narcoanalysis or some other scientific test. The promise of narcoanalysis appeared to calm the crowd, indicating that its legitimacy was greater, presumably, than torture or persistent interrogation. Here, the police rendered narcoanalysis instrumental, even spectacular, and so represented themselves as ethical agents who were eager to solve the crime without resorting to physical torture." The incident described in the book and the reasoning that follows is that the police represented themselves as ethical agents who were eager to solve the crime. Contrast this with the open displays of violence undertaken by the police, which are celebrated and are seen as victories of good over evil. While torture is routine and normalized, the use of truth machines studied in this book appear to be falling out of use, though it did make a comeback in the Hathras case, with the confiscation and the use of evidence obtained from personal electronic devices. The techniques studied in this work appear almost, if I may say so, somewhat dated as we enter the last month of the year 2020. And as investigating agencies turn to the unregulated space of confiscation of electronic devices. The use of information extracted from electronic devices which suspects are asked to provide to investigating agencies has seen a sharp increase. The cases related to the Delhi riots have been one such area where screenshots of WhatsApp conversations form a large part of the charge sheets. Additionally, we've seen in the Sushant Singh Rajput case, WhatsApp chats of random individuals being discussed, extracted, and broadcasted on news channels for many weeks as a media frenzy was created. In chapter 2, attempts at police reforms are traced from the Gore Committee report to the National Police Commission reports to the Malimath Commission. These reports show a desire for police reform that may have also led to the adoption of the truth machines. Interestingly, earlier this year, we have seen yet another attempt to reform criminal law with the setting up of a committee for criminal law reforms constituted by the Ministry of Home Affairs. The stated mandate to the committee, as per the public notice dated 8/7/2020, is to recommend reforms in the criminal laws of the country in a principled, effective, and efficient manner, which ensures the safety and security of the individual, the community, and the nation, and which prioritizes the constitutional values of justice, dignity, and the inherent worth of the individual. But just let's take a look at some of the questions asked. The committee placed questionnaires on its website every few weeks regarding several aspects of the law. Some of them are relevant to the present discussion. One of the questions posed by the committee was, please suggest safeguards to ensure the protection of the rights of the accused and the victim witnesses when recording statements via audiovisual means by the police in the course of all inquiries or investigations. Now, given how rampant custodial torture is in India, the proviso to section 161(3) of the CRPC is susceptible to misuse, as it can never be affirmatively established that the maker of the statement has not been coerced into making the statement. We had responded at length and also stated that technology often hides more than it reveals, and the lack of pressure or threat or coercion cannot be guaranteed even when the statement is recorded through audiovisual means, acknowledging the prevalence of torture and the procedural reforms that may obscure torture rather than prevent it. Several questions relating to the Code of Criminal Procedure were connected to technology, which are revealing in the present context. One such question is as follows. Should the provisions of the Indian Evidence Act be modified to expressly provide for the definition and admissibility requirements for emerging technologies, example, evidence obtained using blockchain technology and or evidence regarding use of blockchain technology such as cryptocurrency? Should section 311A, which is taking your samples for handwriting comparison of the CRPC, be modified to allow for collection of voice samples and alphanumeric Face ID, Touch ID passwords to electronic devices and other biometric identifiers? If yes, what should be the safeguards in place to protect the right of privacy of the individuals concerned? Now, the questions were seemingly asked without taking into account the privacy implications of allowing collection of Face ID, Touch ID, passcodes. Safeguards proposed by the question itself would only legalize the infringement of the fundamental right to privacy. The potential far-reaching consequences of unrestricted access to electronic devices of an accused and its propensity for misuse seem to have escaped the notice of the Law Reform Committee. The book postulates that truth machines and torture are similar in that the underlying logic of both is that, and I quote, they posit that the body can betray the conscious will and reveal the truth, unquote. As is recognized, many forensic techniques could be framed as sources of truth. With new technologies and methods and the seizure of electronic devices, theoretically, the physical act of betrayal is no longer even required. The seizure of mobile devices, which today provide an important total view into a person's daily life, also form a part of a new form of compelled information. At present, there has been no authoritative pronouncement in Indian courts on the right of a person to refuse to turn over contents of their electronic devices to investigating agencies. Mobile phones and other electronic devices contain massive amounts of private information related to persons' personal lives, and jurisdictions across the world are grappling with the tension between the rights of citizens concerning these devices and the requirements of law enforcement agencies for investigation. In Riley versus California, the US Supreme Court held that cell phone searches could not be carried out without a warrant and made the following observations regarding the data contained on phones. The storage capacity of cell phones has several interrelated consequences for privacy. First, a cell phone collects in one place many distinct types of information: an address, a note, a prescription, a bank statement, a video, that reveal much more in combination than any isolated record. Second, a cell phone's capacity allows even just one type of information to convey far more than previously possible. The sum of an individual's private life can be reconstructed through 1,000 photographs labeled with dates, locations, and descriptions. The same cannot be said of a photograph or two of loved ones tucked into a wallet. Third, the data on a phone can date back to the purchase of the phone or even earlier. A person might carry in his pocket a slip of paper reminding him to call Mr. Jones. He would not carry a record of all his communications with Mr. Jones for the last several years, should routinely be kept on a phone. Finally, there is an element of pervasiveness that characterizes cell phones, but not physical records. Prior to the digital age, people did not typically carry a cache of sensitive personal information with them as they went about their day. Allowing the police to scrutinize such records on a routine basis is quite different from allowing them to search a personal item or two in the occasional case. In Riley, the US Supreme Court recognized that a mobile phone is not a simple physical object, but rather the devices today contain vast amounts of personal and private information that record nearly every aspect of their lives. Article 23 of the Constitution of India provides for a fundamental right against self-incrimination. Allowing investigating agencies untrampled and unrestricted access to electronic devices would violate the constitutional protection against self-incrimination, as also the fundamental right to privacy recognized in the Puttaswamy judgment. The passcode to an electronic device is used to access vast amounts of information stored on the device, which has immense privacy implications and for the right against self-incrimination. Routine and unmonitored release of passwords and passcodes can result in reasonable apprehension of misuse and fear that unrelated documents or media would be extracted in a phishing and rowing inquiry and would not meet the test of necessity and proportionality laid down in the Puttaswamy judgment. Professor Lokaneeta provides a hopeful note when she observes that, and I quote, in the Mecca Masjid case, rejection of narco-analysis as evidenced by the CBI and the National Investigating Agency went a long way towards delegitimizing both the technique and the case against the Muslim youth. All were acquitted. The reason I suggest is the inability of the system of policing to create a scaffolding of a rule of law that would withstand the pressure from activists and human rights lawyers and the internal critic from police themselves. Active intervention by lawyers, activists, and the state together with a lack of extraordinary laws such as UAPA, we have also helped in undermining the scaffolding in this case, unquote. In the last few years, we have witnessed an increase in the use of special laws, which were enacted for a variety of reasons, creating exceptions to the three general criminal laws. For instance, the now repealed POTA, the Prevention of Terrorism Act, that is POTA, the Unlawful Activities Prevention Act 1967, UAPA, the PMLA, the Narcotics, Drugs, and Psychotropic Acts, the Prevention of Corruption Act, to name a few. All these statutes make significant deviations from the procedure laid down under the Code of Criminal Procedure and dilute the safeguards provided for therein. A study by the Center for Law and Policy Research of the NCRB data from 2010 to 2018 revealed that the number of cases registered under UAPA between 2010 and 2014 was 0. There has been a steady increase in the number of cases registered under UAPA every year. The number of cases filed under UAPA in 2018 is 1182. The scope of special legislations has been expanding over the years, and different evidentiary standards and procedures are being formulated in the garb of these statutes. The exception is becoming the norm. An undermining of the scaffolding, as described by Professor Lokaneeta, through the continued engagement by lawyers, activists, the state, and academics might help interrogate and challenge the unconstitutional nature of the special terror laws. It is likely that a new set of techniques and technologies will also require the same kind of scrutiny, scholarship, and understanding that form the basis of questioning their validity and use, and might lead to their rejection or the interrogation of that safeguards that are proposed to regulate them. Thank you.
Thank you so very much, Rebecca. That was fascinating. You really opened up the discussion, engaged with Jinee's book, but also raised so many new and interesting questions, especially the question of the electronic devices and you know what it says about privacy, but also at the end identifying newer and greater dangers in terms of the special laws and the special evidentiary procedures that each of these specifies. So clearly, you know, these are major concerns that we're going to deal with. You ended on an optimistic note, though the larger argument was actually more worrying than hopeful. The larger story. Thank you so much, and I guess we'll come back to these when in the discussion. May I now invite Professor Veena Das, please, to make her comments.
Thank you very much, Nidja. I'm really very grateful for the opportunity to make some comments on this remarkable book. But I also want to say that for many years now, it's been really one of the most encouraging things to see Professor Lokaneeta engage this question of torture in both US and India in comparative context, but also over many, many different sites. That is not only what happens within courts, what happens within police procedure, but also, you know, the question of really how does TV spectacles in relationship to, let's just say, the showing of tortured bodies, for instance, has a way in which one begins to think about the acceptance without too much shock of being able to actually see and access in our minds something like the existence of tortured bodies. So thank you not only for the book, but also for your continuous engagement, Jinee, with a very, very important set of questions. I'm going to, since a lot of the two earlier comments have brought up some really fascinating questions, I'm not going to repeat those, although, I mean, it's very fascinating that the Puttaswamy judgment, I thought, had actually really very interesting implications around questions about information and truth, but that's been brought out so well and with much more competence than me by Rebecca Brown. So I will basically ask
three questions for, and these are not arising out of criticisms, but curiosity. Part of them are really the manner in which it seems to me you both move away from the habitual apparatus of political science theory. But then it also creeps back in very interesting ways. And I would love to get some of your comments on that. So first, just the title Truth Machines and, your evocation of core, where you use two basic ideas. You use the idea in Foucault about confession, and the second, the whole movement from the question of torture as spectacle to torture becoming hidden, and the very monumental work of Rajali on this set of questions. But I guess the thing that made me want you to comment more on this is that I'm very intrigued by the fact that political science has taken Foucault primarily around not surprisingly, but primarily really around questions about governance and the technologies of governance, but particularly the question of truth. His ideas develop over a period of time, and particularly if we look at the lectures at the Collège de France, there is a question here that the opposite of truth is not lies, right? And so one big question here was that in the context of confession, where Foucault is trying to relate the issue initially of how something like confession in the context of a Catholic confession moves into the judicial system, there is a very interesting question of adjacency, right? Because in the case of Catholic confession, there is, he takes for granted that he knows what a case means. And it's not very clear to me that a legal case would be similar to a case of confession in the context of Catholicism, because one of the points he makes is that the very language of the truth of sexuality within the kind of questions of Catholic confession poses this question as to what is the risk to the priest, right? That is, if you are actually extracting confessions of a sinful nature about, say, sexual thoughts from children, is it possible that your own desires for the child's body, and later kind of revelations about the Catholic Church have shown how really how central this question was, that whether the priest actually gets contaminated by this particular procedures of getting confession. So one question here is that where and how does the law actually deal with that question? That if you are, even the ones who have written recently in the context of US, actually justifying the legal use of torture with the usual kind of questions, of the thought experiments about a ticking bomb, etc. We all know at a certain level that, that what you get out of inflicting torture is never the truth, right? But there's still the question as to why and how, where is one to find the discourse, which would be a comparable discourse to religious confession on the dangers to the person doing the torture, not only the victim of torture. And I find that a fascinating question because, we just do not have evidence at all, with a little bit of an exception, at least that I'm familiar with Pooja Satyogi's work on what happens within or among police in terms of the fact that you have the phenomena of burnout, you have the phenomena of the bad policemen, you have the phenomena of, the violence that the policemen actually enact upon so-called criminals gets also enacted upon other members of the household, or in familial violence, etc. I would love to know that if one is taking the issue that in a certain sense, in a Foucauldian sense, an apparatus is never simply that which gets over. And if governance is not just about state governance, but the creation of certain kind of subjects, right? Then that creation of that subject cannot be confined only to what happens within law courts. And you broaden that by bringing up questions about forensics, about police, but I think that there is a very interesting question for me as to what other places would you look at for looking at this question of the impact of this widespread acceptance of torture, and the fact that there is a issue where in the movement between thinking about places where confession arose before it takes on the question of expert knowledge within the law, there were lots of reflections on this set of issues in France, for example, which Foucault draws on. But we don't know where I don't even know whether we know where to look, but I would imagine that really what happens within police academies, what happens with regard to police procedures internal to police investigations, and the use of psychiatry, which is not within the court of law, but outside the court of law, in these kind of related spaces or related sites would be something I would say it would be called for. My second reflection on this question of double of truth is that for Foucault, the double of truth comes in relation to questions like praise and civility. How are you doing? I'm doing fine. But in saying I'm doing fine, I'm not speaking the truth. You know that, I know that, right? But we accept that as part of normal commerce. Here, it seems to me that the double of truth is something completely different. The double of truth is rumor. And why I say that the double of truth is rumor is that, again, it's not simply what is presented in the court. That's exceedingly important. And I think what you've done is exceedingly important there. But really, it's also the manner in which the police will take such things as the supposed result of the necroanalysis or the supposed result of brain mapping and use it during the question of normal, confessions obtained in the police station. To give you one example, one very common technique, and I've been kind of talking to a number of people who did have experience of or have heard about people being tortured to just get my bearings right on this. What is very interesting is how the interrogating officer will let slip something to say, well, so-and-so, I don't know what names, let's say Muhammad says that he was, that he's innocent. But while we were doing a necroanalysis of Salim, he mentioned Muhammad as part of that, right? So we are really using necroanalysis not because we know that this person is guilty, but we want to get to somebody else which we are not being able to get at, right? I think if one thinks about those kinds of movements which actually happen in the interrogation room, so to say, then what is really fascinating to me is that the question of the double of truth is something else than then comes up in Care of the Self, or that comes up in the Courage of Truth, which, if you remember, the last sentences Foucault writes before he dies is in fact in the Courage of Truth. And so I would urge that with your fantastic ability to deal with these sets of questions, that you might want to not take machines as literally as you do over here, And that one then thinks about truth here. I think that there is still that judicial shadow falling in some ways on the writing, where you assume that the opposite of truth must be lies. But the opposite of truth over here, or the double of truth, not the opposite of truth, is really rumor. And so I wonder what you would have to say on that. I'd be very interested for you to take that forward. I have just two other short questions. One is really that this question of how can democracies tolerate truth? I think it's a very important question. But so is the question of how can authoritarian regimes tolerate truth? We have been too sanguine about thinking that there is a very sharp divide between democracies and authoritarian regimes. And if you look at the changes that, for example, have happened in modes of governance in, let's say, China, in which the idea that an engineering state does not really need to use that much violence, right? That it can get its citizens to actually be compacting or being consenting to what may be happening to the Uyghur Muslims or what may be happening to Hong Kong, as long as their infrastructure works. And the COVID-19 was fascinating. That once China began to acknowledge that there is a epidemic, they actually had the infrastructure to know exactly where to place people in quarantine, what kind of medicines they needed, what kind of food they needed, what kind of childcare they needed, etc., through getting the level of local cadres. And so the use of violence, I think, becomes quite different as compared to other authoritarian states as well as other democratic states. So I would wonder whether we should shift that question now and not simply assume that the scandal. I mean, I myself have written saying, yes, this is the scandal that in democracies we use torture. But the more I've been thinking about it, the more I think that it helps to make this distinction between authoritarian and democratic regimes and still leave us somewhat sanguine to think that this is an exceptional thing to happen in democracies. And so I would say that would be my second question on this. And the third is that I'm not convinced by your use of notions like semi-state actors. I mean, I don't know why political science is so given to the idea that they're state actors and non-state actors, when we know that most of the violence, in a certain sense, happens because semi-state actors are also state actors, so to say, right? I could elaborate more on that, but it doesn't seem to me that when one says, how does medical testimony come to be accepted testimony within the court of law, we're really in the regime of thinking that there's something called semi-state actors. There is again, in a Foucauldian framework, there is this normal way in which he deploys the vocabulary of things like flows and junctions and locks, and it's a little bit of a mechanical vocabulary, but it shows that Agamben notwithstanding, which is a gross misreading in my opinion of Foucault, there is no sharp divide between sovereign power and disciplinary power, precisely because there are sovereign selves within disciplinary power, and disciplinary power uses the notion of sovereignty at particular kinds of moments or through particular kinds of junctions. And I think there's enough evidence that in a way you show that too. But it would be great to kind of make that, I would just say it would be great to get rid of that vocabulary, because, I've been just looking at the data set on Africa, where where people find no difficulty in saying this is state violence, this is non-state violence, this is semi-state violence. And, it's very hard to think that in Africa, any of the genocides that have happened or any of the ongoing conflicts, such as in Sudan or Somalia, or now in Ethiopia, where the non-state and the state are completely implicated into each other. And my last point would be, I think it's really what you open up, and through your earlier work too, is the question of the machine, not just as the physical machine. So there is, I think, a really interesting question, which is around questions about what will happen with digitalization, where again, it's not the question of what the physical machine is, it's what the algorithm is, right? And if you begin to see, they say something like in China, if you begin to see that citizens will completely accept the fact that there is an algorithm, the government knows exactly what you are saying, what you're not saying, because this semester I've been teaching a lot of students spread over Singapore, China, Japan, as you might have been doing too, South Korea. And the Chinese students know exactly that what they're saying is being overheard by the algorithm. They're not 100% sure that, and although China has a huge apparatus of people just to look at what is being generated on the digital media, right? As we know from the 50 Cent movement and from leaked caches of emails, etc. But what is so fascinating is that the technology over here would require a kind of combination of human-machine interactions. And I'm not sure that the notion of cyborg at all captures that kind of an engineering model, so to say, in which the issue is really about what to do with the fact. I mean, I can imagine that given the fact that so much of data might actually become available both within democracies and within authoritarian regimes. And there's an amazing convergence in a certain sense of how algorithms travel across these kinds of situations. Whether we need to think about the question of torture, whether this will raise questions of torture in new kinds of ways. Because one of the things that the coupling of truth and rumor does is that it shows that torture is something which the police use to destroy communities. I think it's not just something that they use to destroy individuals. And, this is very clear when they try to get, like, if you have, say, Tada cases in which Bombay blast, you have 125 people who are arrested in the beginning. And they have to show conspiracy for each of those, right? So that they have to then create these individual stories. How come a driver working in this lowly area in Mumbai could have got in touch with, or could have been part of the network of Tiger Menon, right? That requires a certain kind of creation of stories in which they need to then get people like their relatives and their neighbors and so on to actually give witness or say, yes, I saw such and such Pakistani citizen actually, in such and such place. And when you talk to these kinds of people who were not themselves tortured, but who were terrified either by inducements or by threats of torture, you really begin to see that what torture does is not purely destroy individual bodies, but the entire, range of questions about how community tends to be destroyed. Because, imagine if your brother-in-law has ended up giving evidence against you in court, what it does to your relationships, to your ability to maintain kinship, for your children to inherit, what relationships might be. And so I wanted to sort of say that the last bit I wanted to quote was just 2 lines from Coetzee, when he's arguing in both Waiting for the Barbarians and The Diary of the Bad Year, that a passage, that there is a certain sense in which this is not purely a question about the abrogation of law, but also something like the abrogation of what it is to have a human form of life. And that would require that we begin to think about torture, not just as what happens within state apparatus, but also what happens within families. And I'm not just talking of psychological torture. I mean, it is quite amazing to see that the kind of use in some ways of what the courts will not call torture at that point is in fact something you can see in the case of rape victims, you can see in the case of child abuse, you can see in the case of battered women syndromes, you can see in the case of lynching crowds, for example. And so I wonder whether we really need to think about that not as, oh, this is semi-state or this is non-state, but the manner in which these technologies actually proliferate across these things. So thank you for helping me to formulate these questions through your remarkable book. And there's clearly much serious work to be done in this matter. And we really look forward to, I don't wish continued engagement with torture for you. I wish it was not necessary, but you are one of the persons who's really made it possible for us to, along with, I must say, all the remarkable lawyers and so on, as who actually, kept this question something which is alive in conversations. Thank you.
Thank you so much, Professor Das. Such profound and deep philosophical questions as you have raised. We're running a little bit late, Jinee, so if I may ask you to respond to all these brilliant comments you have received from Professor Das, from Rebecca John, from Justice Murlidhar, and we'll be eating into discussion time, but if you'd like to take 5, 7, 8 minutes. I don't think you can deal with all of these questions, but there are also some questions in the chat box, but we can come to that in the kind of formal Q&A if you'd like to deal and respond first to the panelists. Thank you.
Thank you so much. I'm just overwhelmed with your generous reading and just taking everything, in such a transformational way, much beyond what the book actually attempted to do. And I'm really grateful for that. So first is just that feeling of being very overwhelmed by the brilliant minds, and even in the Zoom room. The thing that I would say, and it is of course impossible for me to even start both articulating but also engaging with the range of responses. So maybe what I'll do is I'll just take a few themes that were either across the comments, and maybe try and say something in relation to that. One of the things that and I want to start off with that is sort of really acknowledging, the role that civil liberty, democratic rights movement, and lawyers who are really activist lawyers have played in sort of both informing my work, but also sort of and here I should mention like the conversations with Rebecca on the way, during, and many other lawyers, right, is really crucial for the reason that I think a lot of these questions were already sort of emerging in the way in which what was available and not available to us, right? And here I'm just referring to the fact that, the role that depositions or having access to depositions in the Mumbai case, for instance, right, was a reminder of how difficult it is to capture that part of the process in the way in which we think about violence, right? So we have sort of reports on one hand, right? And but I think bringing the narratives as a part of our understanding, it becomes really crucial to how we are thinking about the truth machines. And I just want to hence maybe link it to the fact that you actually see that to Professor Das's question here, that when we are talking about the question of confession, right? You're absolutely right that, there is a way in which when Foucault is talking about it, but also in the context of US, Peter Brooks has sort of talked about the confessional culture coming from, both sort of a religious confession, that Christians may be involved in, but also in terms of what you would confess in terms of a psychologist, right? In front of a therapist and so on and so forth. So I think the need to understand, distinct sites of where confessions come in, right, is really, really important. But what is fascinating for me, and that's why I think, I keep going back to sort of how the legal process deals with the question of confessions, is precisely because there seems to be an unexplained reason why confessions continue to play a major role. So if you go back to sort of thinking about, even in the Indian context, right? For instance, Abhinav Sekhri has this essay on police coercion where he's tracing how, despite the fact that basically you see that Indian police are not allowed to record confessions, right? And this is a colonial law. You end up seeing that the rate of confessions don't go down, right? And the reason, even in the colonial times, right, that's something, you find that in the Indian context, confessions remain sort of a mainstay. And I think the reason why that does is precisely because of both sort of the legal accommodations of the kind that Justice Murlidhar was talking about, right, in terms of very internal logics, right? So it's, and this is just also to say to something that Rebecca brought up, which is that when the police are talking about recovery, right, it's not that I'm interested in, sort of totally accepting the narrative of why police actually use torture. You're absolutely right that they use torture because that's sort of one of the ways in which they destroy communities. They end up wanting to use torture because that's sort of been the culture that has existed due to impunity. But I think another reason that it becomes extremely important is sort of the kind of public or cultural production of truth, right? That is very central to how people respond to police techniques, right? So for instance, if we just take, two instances, and one is sort of the Arushi case, right? And Rebecca, of course, knows this much better than me. But what was striking for me was, despite the legal inadmissibility, right, of the evidence of as a result of these truth machines, the popular campaign to challenge the conviction of the parents depended on the results of narco analysis of Himraj's friends, right? And I think that is always a reminder of the kind of cultural production that the public wants sometimes, right? Which is both in terms of the truth machines sometimes, right? In the Hathras case, when you see that the memo that comes out from the state authority is mentioning narco analysis as a central way to intervene, right? Despite having a range of other investigative techniques, I think it sort of points to the popularity of sort of a cultural production of truth. And the reason why, I think you're right that at times it may seem that I'm mostly, tracing the history of truth machines, which I am very invested in because of the kind of, actually merging of the body and mind in some ways, right? That you end up seeing. But at the same time, it's also pointing to somewhat of a more cultural phenomenon, right? Where confessions right, or information which are directly taken from the body, right, and accessing the mind become the primary mode through which investigations work. And let me just say that, so even if in certain cases, these techniques don't end up getting used, you end up sort of a kind of movement that Professor Das was talking about, right? That basically, even in the Delhi riots case, right, we've seen that confessions supposedly by one set of people are then used to, sort of target others. And, one of the remarkable things is those of the people who have refused to sign or saying that I don't sign with consent, these are all sort of phenomenon which reminds us of a kind of a culture where the popular legal, right, sort of come together and ask us to sort of re-examine the overemphasis on, sort of focusing on the body and the mind in some ways to access truth. I just take maybe, one more minute to sort of say something about, the idea of the state and the non-state. Yes, I have in some ways, political science and political theory, I have a deep relationship, as well as deep ambivalence about my discipline, and draw from other disciplines as well, right? But one of the things that I think I come back to, and I think the current moment is asking us to think through even more, is sort of recognize that state custody does have a meaning, which has which requires a particular kind of focus and analysis, right? When we are thinking about the kind of emphasis required right now on police or prison custody, I think I even as one recognizes that there are of course other sites which intersect, which form, which sort of inform and constitute certain ways in which the state actors perform. There is a way in which it's a reminder of how just because the police and prison officials still continue to be those who have the legitimate, right, seen as the legitimate actors, who have the ability to transform people's lives, through like even a low order infraction, right? Going out to get milk in a pandemic may be enough, right? Or to sell your wares during the pandemic may be enough to really impact your life, is something that I think makes me still want to hold on to some of these categorizations, which I try to do through these distinctions between state, semi-state, and non-state actors. Never for a moment, learning from particularly anthropologists and Professor Das's work as well, never for a moment sort of thinking about them as different, completely rigid categories, right? But at the same time, I would say that at this particular moment, I think there's something about that, something that I started off with, which is, one of the biggest insights from this civil liberties and democratic rights movements in India, and also then seen in the context of the jurisprudence, is sort of this idea of custodial violence. And I think, I do sort of want us to think about custodial violence as a very specific kind of violence, even as we sort of think about the boundaries of it. So I know I did a completely inadequate job of, sort of responding, but I hope that, as we sort of open up the conversation, we can, sort of get back to some of these questions, but deeply, deeply grateful for all the, generous engagements and so much to think about as well. So many thanks.
Thank you, Jinee. So we have a few questions in the chat box. I can read, if you can't read them, or for this, or because I think the audience does not have access perhaps to the chat box. So let me read out a couple of questions, and maybe you can take one and one of the other panelists can take the other. The first is, how can we ensure that legal gatekeeping, also this is from Manpreet Dhillon, how can we ensure that legal gatekeeping of novel forensic evidence in the trial courts is strengthened before these truth technologies become normalized in the Indian legal system? Do you want to take that?
Sure. I mean, I really feel that maybe Rebecca might want to respond to that, given the kind of experience, but I can also come in.
Why don't you weigh in on this, and I'll ask Rebecca to take the other one, which is on how reliance on impartial scientific investigation methods has changed police investigation, especially in the context of Selvi and Ritesh Sinha. So go for the first one, please. Thank you.
Yeah. So I think, I mean, one of the things that you realize, right, is that in some ways the lives of these techniques, right, before they sort of even enter the realm of forensics, is very much linked to particular cultures of policing, right? So, and what I mean by that is, I trace the origins of lie detectors, brain scans, and narco analysis in the US as well, right? And in the sort of 1930s, and where polygraphs and sort of narco analysis become really central, again with a kind of a similar understanding that they'll help replace third degree, right, which sort of in the 20s, 30s becomes a major issue in the context of the US. And then you realize that basically it was not so much, although there were certain originators, right, basically who were, linked with the invention of these techniques, right, the scientific reliability and validity never becomes that much of an issue, right? So basically, Jeffrey Bunn has this amazing argument where he says it's come up because of a spectacle of science, meaning, it's pulp fiction that allows for the polygraph and, sort of Wonder Woman and the, lasso, right, are really where, this production of truth becomes more important. And yet, in the Kavanaugh hearings, right, more recently in the US, polygraphs, the discussion became on polygraph, the use of polygraph, right? So again, not legally necessarily, right, but in a way which, sort of reinforces the kind of, confession paradigm. And when you look at what happens in the Indian context, you find that the one attempt to sort of see whether brain fingerprinting, right, and BEOS, the Indian sort of invention, when there's an attempt to sort of see whether this is scientifically reliable or valid or not, when the committee says, Nagaraj committee says, no, it's not by any means, the response is sort of, you basically disband the committee. Now, the reason why I'm saying this is because in some ways the courts are not able to somehow focus on the reliability and validity in the way that you would imagine it necessary when there is an acceptance of a particular kind of techniques, right? And the idea then is to say that even as we are taken by this logic of science and experts, right? It's extremely important, not just for this set of forensic techniques, but use the same framework of trying to see how much faith there should be for any forensic techniques that are introduced.
Oh, thank you. So I think we have a few questions here that each of the panelists might like to address. May I invite Rebecca maybe to respond to the one, how have reliance on impartial scientific investigation methods changed police investigation? You have personal experience of all this, I'm sure. And then I'll come to the other two.
So I don't know what is impartial scientific investigation. I don't know what that means. Because it is important to be cognizant of the fact that no scientific technique is completely reliable or free from the possibility of error. And the problem we have in India is that investigating agencies and even courts believe that certain scientific techniques are free from error. I was deeply disappointed with the Ritesh Sinha judgment, but it is the judgment of the Supreme Court, so we have to accept it, where it made admissible voice samples by using Section 311A, which was with respect to handwriting. And we do know from research from across the world that there is, even with respect to voice samples, there is a large degree, great degree of error. So I think the police will increasingly use these techniques and claim that this is science. I like to refer to the judgment of the Supreme Court in Mukesh versus State, the Nirbhaya judgment, where the odontology report was used as a great scientific technique, whereas odontology has been considered as junk science across the world since 2011. So really, I think we are a little ill-informed about many of these techniques. And the minute a scientific expert comes to court, and because of the protections he has under 45 and 293 of the Code of Criminal Procedure, he or she tend to get the upper hand in proceedings. But I think the way forward is to challenge these, because in India we don't have the parallel to of the Dauber test, where we talk of where they have to cross certain essential prerequisites before a particular scientific technique is treated as admissible. So I think there is need to be a little creative here, trial lawyers particularly, and challenge the admissibility of many of these reports, whether it's capable of replication and all the other rules which are part of the five-pronged Dauber test, which is internationally accepted as one of the better tests with respect to admissibility of forensic techniques. So in response to this question, I don't think that there are impartial scientific techniques. I think all of this is evolving, and as we go forward, we can question the impartiality of each of these techniques. The other thing is the law in India actually says that these scientific techniques are corroborative in nature, and therefore they can only corroborate and not be the central piece of evidence. So we must look at all of this in this way. I think investigative agencies would like us to believe, and like courts to believe, that these are perfect sciences, but the test is really to question that and to test that as we go forward.
Yeah, thank you. Of course, the questioner did put impartial within single inverted commas, so presumably she
probably
knew what, yeah, what kind. So that from that flows, I think the question that I would invite Justice Murlidhar to answer, which is: has any forensic technique been put on trial where scientists are asked to testify to whether a forensic technique is scientific or not?
Good question.
Yeah, actually, it's an interesting question. I'll pick up one example of the NDPS cases. Rebecca would definitely be aware of this. A sample is taken, tested in the forensic sciences laboratory, and the test result is produced along with the charge sheet. And the defense invariably asks for another sample to be taken for another testing. Likewise, in the food adulteration cases, the defense will invariably ask for another sample to be taken. And sometimes the courts do permit the sample to be sent to a laboratory different from the one to which it was sent by the prosecution. Now, lawyers working in these particular areas where scientific evidence becomes quite crucial. I agree with Rebecca that largely they are corroborative, but they can clinch the case for either the prosecution or the defense. Likewise, in the DNA analysis, you could ask. That's why creative lawyering, like Rebecca said, could ensure that you have another shot at testing the veracity of the report. And there are ways of cross-examining the scientific expert who comes from the forensic laboratory. If you are armed with scientific literature, you know where the weakness of that scientific test lies. So which means as a lawyer, you have to equip yourself. As judges, we have to equip ourselves. So every time a new scientific technique comes before the court, it's a whole education process for us. So we do, expect that experts, not just from the forensic sciences laboratory, but other experts would come in the court to talk on the veracity of this report of this scientific officer. And that does happen. I've had cases where a DNA analysis is questioned rigorously by the defense lawyer by cross-examining very closely the witness who came from the FSL. So these things are possible, but in the run-of-the-mill cases, and I must say this also, let's say the rape cases, although we say that DNA, and Rebecca, I don't know whether you'll agree with me or not, although we say DNA can only corroborate, very often DNA becomes the clincher. It helps the court fix the conclusion more easily if the DNA test is unchallenged. Likewise for the defense, if the DNA supports the theory of innocence of the accused, then the defense will readily grab it and rely on it. And this is exactly, it ties up with what Jinee is saying in the book about the Arushi case. So where scientific evidence on a preponderance of probability advances the cases of the accused, the defense will use it, notwithstanding the unreliability, general unreliability of scientific investigation. But the courts will insist that when the prosecution uses scientific evidence, that it satisfies the requirement of proof beyond reasonable doubt, even if it is a corroborative piece of evidence. I don't know if I've summed up this. Rebecca can correct me if it's not correct.
Yes, it is. Yes, it is. But because we've raised the Arushi case here, and I've been wanting to say this for a while, but I've held myself back. See, while the narco-analysis test was being used by persons outside the legal space to say that they were innocent, because the couple were also subjected to narco-analysis test, and the friends of one of the deceased were guilty. This was never evidence used in court. And nor did we as lawyers ever rely upon it. So it's not part of the acquittal order of the Allahabad High Court. It was never argued. But I will say that there was some interesting scientific evidence there which was robustly contested. For example, there was one comical crime reconstruction report which was produced, and which was produced by a forensic laboratory in Gujarat, and this was the basis of the conviction order. It was so comical that it could not withstand judicial scrutiny in the High Court. In the DNA report, which was produced in that case, and this is perhaps an answer to some of the issues raised by Justice Murlidhar. See, it's one thing to say that there are times when DNA can become conclusive. But what do you do when the investigating agency itself is complicit and is lying? So here, an entire DNA report was produced. But one portion of the DNA report, which showed that there was some connection between a let-off suspect and the deceased, because his pillow cover showed they were able to extract the DNA and blood of one of the deceased. The prosecuting agency came up and said it was a typographical error. Now, this has been junked completely in the Allahabad High Court judgment, where said that there was no scope for a typographical error at all. So while we're dealing with scientific tests, we must also be cognizant of the fact that everything is not black and white. And when there is a black and white document, there is a spin over that as well. And it takes a great deal of effort to set it back, and it took us a great deal of energy and effort to tell the court that it was not possible that that one piece, just that one line was a typo and the rest of the document was correct. And the court accepted our contention. So Jinee, we did not, and I don't think you've suggested it, the narco analysis, both sets of accused were subjected to narco analysis, but it was never part of our arguments in court, nor was it considered as evidence in court. Of course, people who were fighting for the couple, perhaps, and in the media narrative, it became a very important, piece of evidence, but it was really nothing in court.
Sorry. Go ahead.
Yeah. No, so Jinee, I think this answers the other point you made in the book. The cultural valence this has, the police needs to come before a television camera and say we've kind of cracked it and we have solved it and, this is the trend of investigation. So that pressure on the police to somehow say we're doing a job, all this is very useful, which is why all these WhatsApp chats you're talking of, everything is produced. I mean, either it's given to the media or it's displayed on a television screen, knowing fully well this will completely destroy that evidence. And the other thing, I just supplement what Rebecca said, good lawyers will go into depths, and I must tell the questioner this, of the sanctity of the sample. There is a whole protocol on the sanctity of a sample. Apart from the seals and the recording of, when you collected the sample, where did you store it? How was it carried from, let's say, the laboratory to the police station, back to the laboratory? All this is recorded.
Chain of custody.
That's right, chain of custody. So a good lawyer can demolish the so-called scientific evidence if he's able to show that the sanctity of the sample was not maintained. And much is attached to this in the legal discourse.
Yeah.
So there are very many ways of, tightening the weaknesses as well as demolishing the scientific evidence on the basis of those weaknesses.
Thank you. I think Jinee had a comment there, but in the interest of time, I'm going to invite Professor Das to answer the last of the questions we have here in the chat box. I'll read it out for the larger audience. It says, in rape cases, we know from the womanist scholars that the police confiscates their clothing for forensic analysis without providing a spare pair of clothing. The victim has to borrow clothes, blankets, etc. to clothe herself. Is this not custodial torture under the sign of science? And why does the judiciary, which of course is not the question that you can answer this bit, why does the judiciary tolerate such violence against rape survivors? Professor Veena Das.
I'm not sure I'm the best person to answer this question, but I'll try. One is really that a question really of where can you project a concept. By definition, a concept is something which one should be able to project. Now, whether it's a right projection or a wrong projection is a very important question, right? And so, when one says, well, their clothes are taken away because evidence has to be gathered. Actually, there's a very, very interesting book by Simina Mullah, which basically looks, especially in rape cases, she looks at what happens in the emergency room. That is where the rape victim is first taken, which is where both forensic evidence is being gathered and there is the, it's a space which is both therapeutic and forensic. And that really has an impact on the way that forensic nurses, for example, are compelled to behave. Because one of the very interesting questions with this kind of evidence is that this is evidence likely to disappear very fast, right? And so there is the urgency of time over here in order to be able to able to get that. And of course, there are a whole lot of things around saying, well, how can you actually do this, keeping the dignity of the victim in mind? And, those are, I think those are easier to put in. Whether I would want to say this is torture, I mean, to me, there is a really interesting dilemma where just having worked with the actual ways in which torture is committed, for example, on children, on the, I mean, the brutality of the pain in a certain sense, you could go on extending that, but it's something which I feel a little hesitant about, because it seems to me that in relationship to the actual demands being made upon us, when you hear an 8-year-old child saying how a pestle was inserted in her vagina, I somehow cannot create an equivalence in my mind between thinking of that and the question of taking away clothes. So I think there is something to be thought about there. I'm not giving a yes or no answer, but I think that on the science part, I'm much less, I mean, I think that it's very common in the debates, especially with kind of more enlightened social scientists and maybe judges and lawyers, to put scientific within quotes. I'm not that sanguine about it, I have to confess, because to me, yes, error is part of scientific proceedings, right? I mean, it's normal to science that there would be error, right? And that's why there is this continuous question of, how do you actually take back that, or how do you correct it? What are the ways? The other is that disunity of science is something we do take for granted, so that there is a certain sense in which no scientific evidence or no scientific question would ever be something which goes uncontested in the scientific community itself. What is interesting to me is Foucault's notion of the grotesque, where he says that the real question that happens is when tokens of power come to be substituted for tokens of knowledge, right? And he actually brings in the fact that when psychiatry begins to be allowed in the court in France in 1832 onwards, that's partly because the law faces an impasse. That is because a new pressure has been put upon motivation as we move from very arithmetic notions of punishment. So as long as one said, well, punishment is to be proportionate to the crime, nobody had to actually establish motive. But once the question that the psychology of the person who has committed the crime becomes part of judicial scrutiny, it becomes then important to say, is this person mad, or is this person a criminal? And that comes up primarily in relationship to motiveless crime, right? So there is that institutional question of when is it that a space is made for a certain kind of expert knowledge. But this expert knowledge might also be something in which constantly tokens of power, and I think Jinee's book shows this really very, very well, that there are tokens of power which are constantly being substituted for actual evidence which is available. So one thing that has happened is, again, I would say that there is a wider context right now in which so much questions of mistrust of science have actually come up. And part of that is the way in which criteria about what is successful science have come to be redefined, in terms of absolute metrics, which can be constantly gained, right? So, so journals have consortiums to say, if you're writing a paper, you cite me, right? And we will make sure that somebody else writing a paper somewhere else will cite you, and so then universities go now much more in terms of saying, there was, in my university, there was even a proposal to say that in judging particular scientific, expertise, we should see how much Twitter following there is, right? 10 years back, I would have said, this is impossible. Nobody would, in a university administration can ever propose it. But the fact that these kinds of forms have become available, to me, is a sign in a certain sense. In the US, it goes along with a very anti-intellectualist tradition, which is not a new part. right? But I'm very hesitant in the way in which this kind of anti-intellectualism actually seeps into, into general statements about, so-called science and et cetera, et cetera. I think we need to be really much more careful. So even in the Bhopal case, we recently had a paper in which somebody who's been actually just taken the existing data sets and shown that women who were exposed to methyl isocyanate and who were pregnant at that time and who did not move out up to 100 miles were likely to give birth to children with larger birth defects, with higher rates of cancer, and so on. And this requires really enormous amount of hard work. And so I would just say that just as I think I'm very respectful of the legal expertise, even when I disagree with it. I do think we need to not be, simply assuming that something like, we don't want to say that nothing like evidence counts, but we need to be very mindful of the conditions under which evidence can or cannot be produced, right? So it's a long-winded answer to say that there are really deeper issues that this question raises. And, I'm notorious for the fact that I'm sorry, I don't have a prescriptive bone in my body. So I can't say, oh, this is exactly what should be done. But I think I'm interested in thinking what are the kind of discursive forms that get generated and what do they tell us about the manner in which we begin to think about. Can I say one other thing? I mean, during COVID-19, it was so obvious to me that the way that people spoke about science, right? So they would say, we know the projections about how many COVID cases are likely to find if this is not done. And I'm like, please, can you give us the upper bounds and the lower bounds? Given that probability, we don't know how much testing is being done. We don't know how the virus is mutating. We don't know whether these are clusters, right? And so I think part of the challenge is for lawyers to not insist that scientists speak with absolute certainty. I think we would have to think more about, what is the place of the fact that science is always done in an environment of uncertainty, right? Otherwise, why would you be doing it? And I think that raises really very large questions about what is the relationship, of this truth with the certain kind of authority which which scientists are asked to perform in both public policy and in the context of legal mechanisms. I mean, suppose we were more tolerant of saying, all right, we know that we can't get absolute certainty. Can you tell us what is the trust you have in these particular judgments? And if that didn't become, I mean, that's part of the adversarial process, that you're scared to say this because you'll be torn apart. But I think those are really, for me, very compelling questions. But thank you for that question.
Well, thank you for that very, very profound answer to this question. Of course, one can always hope that the judiciary would, if not consider this kind of thing custodial torture, would nevertheless think that this is something that needs to be addressed. But I mean, on the popular anti-intellectualism, actually it works two ways. One is the way in which Jinee's book suggests, and Rebecca also commented on it in the context of the Hyderabad encounter and so on. But, so there's this, and the media narratives around the Arushi Talwar case. So there's the popular sort of, the people, so to speak, reposing faith in science when it takes the form of narco-analysis and lie detectors. But at all other times, anti-intellectualism and anti-science. So science plays various, it's a complicated story. And as Jinee's book points out brilliantly, I think we've overrun our time quite considerably. So I would sort of happily go on for another 3 hours. This has been an absolute intellectual treat, not just for me, I'm sure for the entire audience. I have rarely been in the company of such a brilliant set of panelists. So I thank you all. Thank you, Jinee, for writing the book that made this possible. And thank you, Justice Murlidhar. Thank you, Rebecca. Thank you, Professor Das, for being here. Thank you, Pratiksha and Jhuma, for organizing this. Thank you all for a really, really splendid panel. Thank you. Good night.
Thank you.
Thank you.